Are you guys ready?
You guys good?
We're good. All set, right? Very good. Welcome to the second press conference. Good morning. We're here to discuss cashless bail, which was passed by the New York State Legislature and signed by the governor into law. Politicians often overstate the case in many things, but it is impossible to overstate how bad this is. One of our most fundamental duties as a legislator is to keep our citizens safe. This law betrays that duty. Cashless bail makes our streets and neighborhoods more dangerous. It leaves our residents, including those who are most vulnerable, subject to more crime. Cashless bail handcuffs our law enforcement, and it erodes the rule of law. Now, there's a number of speakers today who will describe in more detail the effects of what this does to our communities and to our county. I wanted to give you one example, and actually it connects with the press conference that the county executive and the opioid task force just had. Nassau County and Long Island in particular have suffered too many deaths, too many destroyed lives, too many distraught families because of the opioid epidemic. Under cashless bail, courts are prohibited from fixing bail for drug dealers except those charged as a major drug trafficker. Now, to give you an idea of how difficult it is to charge someone and convict someone as a major drug trafficker, last year there were 35 across the state that were actually convicted. So in essence, the vast majority of drug dealers will not be subject to bail. What does that mean? Someone who's dealing drugs in our neighborhoods to our children, that's peddling this deadly stuff to people who are addicted, that is destroying lives, will not be incarcerated, will not have to pay bail. They simply will give an appearance ticket, released, and sent right back into the streets, right back into the neighborhoods, right back into the schoolyards to peddle drugs. It's just insane. We urge our state legislators to go back and repeal this law. As I said at the beginning, one of our most fundamental rights is to protect our citizens. This law is something that is going to make all of our citizens less safe and is going to create incredible problems for our county. I would like to introduce now, to say a few words, the president of the Nassau County Corrections Officers Association, Mr. Brian Sullivan.
Thank you, Rich. Thanks, Rich. Brian Sullivan, president of the Nassau County Correctional Officers Benevolent Association. I have a few words just to speak on this, and I'm going to reiterate a little bit about what the majority leader said. The world is upside down right now. Over the last couple of years, I've done my best to expose issues in our arraignment courts where criminals have been released back into our communities for various crimes with little or no bail, or simply released on their own recognizance, endangering our citizens. But now, we've taken a giant leap off a cliff and are living in a very dangerous new world. Under what has been termed as criminal justice reform and bail reform, recently passed through the New York State budget, criminals in New York State will no longer be given bail for all misdemeanors and all nonviolent felonies. They won't even be allowed to be taken into custody by our police. That means that starting January 1st, 2020, people who commit many different types of crimes in New York will be immediately set free with what's called a desk appearance ticket. Much like a parking ticket or a moving violation, this means that the criminal will be immediately freed from the scene of the crime and advised to come back to court at a later time. Some examples of crimes where appearance tickets would be issued are many different levels of arson, DWI, certain levels of rape, burglary, possession of a weapon on school grounds, selling drugs on school property, stalking, reckless destruction of property, possession of child pornography, and forcible touching. An appearance ticket? Really? This is what we're doing? My favorite, as the majority leader said, under this new dangerous world of reform, when it comes to drug crimes. Only major drug traffickers will be subject to being taken into custody or given a bail. A major drug trafficker is someone like El Chapo or the guy that we're holding, the East Coast leader of the MS-13 in the Nassau County Jail right now. Major felony drug traffickers. Do you know what this means for us here on Long Island, our beautiful suburb that's been overrun by a devastating opioid crisis? Drug dealers walk free. You could have 10 pounds of heroin and fentanyl in your possession, and you're going to get a desk appearance ticket. But but make sure you come back to court in a month. That's the new reality under bail reform. Guess what happens when they don't come back to court? The judge can't even issue a warrant for their arrest. He or she must wait 48 hours while someone tries to contact the criminal to ask him nicely to come back to court. One of the biggest dealers and importers of heroin on Long Island is the gang MS-13. We're going to issue DATs for them to come back to court at a later date. Do we need to even bring up the subject about flight risks? Risk of flight is not even a consideration either under this reform. Also written into this bill is willful and persistent refusal to come back to court can subject you to being taken into custody or being held on a bail. What is willful and persistent? 2 times you don't come back? 35 times you don't come back? Who knows? It's not specified. Lastly, and specifically written into this new law, is that there is no public safety component that will be used as a consideration for detaining any of these criminals. Put simply, no judge in New York State has the ability to take into consideration the risk that that criminal before them poses to the safety of the public. This was specifically and purposely addressed into the law because those who created it don't want judges to have the ability to detain criminals because it does not give the criminal the benefit of the doubt. Why even have judges anymore? The criminal gets the benefit of the doubt, but the safety of the public be damned. Under this new law, crime victims are completely defenseless. Criminals and desperate drug addicts can come into your home at 3 a.m., rifle through your valuables, burglarize your home, and they are issued a desk appearance to come back to court. Drug addicts can't be even forced into rehabilitation programs as they are now when they're taken into custody. They're simply released to their own devices. Drug dealers can push heroin on your kids at their schools and they get a desk appearance ticket. This travesty has been labeled by its creators as beneficial to low-income communities and benefits people of color. I've never heard of such nonsense. Black people don't commit crimes. Brown people don't commit crimes. White people don't commit crimes. Criminals commit crimes. I don't know how much clearer I can get than that. This new law harms high-crime neighborhoods even more because it doesn't take criminals off the streets in those neighborhoods. It leaves them there to prey on innocent victims. Legislators at Albany who represent such districts have told us as much when we were there fighting against this new law. The New York State Senate and Assembly voted for this, and it was signed off by the governor. Our own Long Island 6 Democratic senators all voted in favor of this. Why was it done in a budget? Because it's lumped in with numerous other issues and hidden from public scrutiny prior to being implemented. If it was given the proper public airing, I guarantee it would never have been allowed to happen. This has to be corrected. This law needs to be repealed for the sake of public safety in New York State. What's going on in Albany is an affront to every single law-abiding citizen in the state of New York. Thank you very much.
Thank you, Brian. The president of the Nassau County Police Benevolent Association, James McDermott.
Good morning. It's always good going after Sully because I'll be nice and short. Everybody will like me then. For obvious reasons, we believe the reforms went too far. The judges should have more discretion in felony cases. One of our concerns is that when police officers get involved with arrests, where they, have a perpetrator that's resisting arrest and fighting with us, these people will be released on appearance tickets, and they'll be back on the street. They'll fight with the police, and hours later they'll be back on the street, something that's unacceptable to the Nassau County PBA. We would urge the legislature to revisit this issue during the session so items like that and what Sully spoke about earlier can be discussed in detail and addressed. Thank you very, very much to everyone, and have a nice day.
Thank you. John Wighouse, president of the Detectives Association, Inc.
Thank you. The bail reform that the governor included in the budget is an imminent danger to the residents of Nassau County and all the residents in New York State. With just 2 detectives assigned to our warrant squad with over 100,000 warrants, outstanding warrants in Nassau County, including that are subject to absconded and violent crimes that continue to endanger our county and society. We predict with this delusion of so-called criminal justice reform, the warrants will triple. The primary function of government is to protect the people it serves. This bill does nothing more but empower and embolden the criminal element and places law-abiding citizens in peril. Nassau County residents should be keeping a scorecard of what bills our state senators and assembly members are voting on and hold them accountable. Thank you.
Kevin Black, the President of the Superior Officers Association.
Good morning. Thank you for coming out today. This is a very important issue to members of the SOA. It not only takes away discretion of police officers in the street and supervisors who are on the road, as well as desk officers, but most importantly, the judges who try these cases are having all discretion taken away from them when it comes to felony bail amounts. Literally, we won't even, it used to be you were worried that we'll bring the person in and release them on an appearance ticket. Now you're not even going to release them. You won't be fingerprinting them until they show up for court, if they show up for court. And as John Wighouse just said, we expect the amount of warrants to triple in a short period of time. On a totally different level, in 2017, New Jersey eliminated cash bail. Since then, the cost of pretrial services has more than tripled past what the estimates were before. And according to the latest report, the cost will be unsustainable in the future unless the state starts to contribute more money. So on the side where the legislature is saying, oh, this is going to cost less because of this, this, and this, the pretrial cost will exponentially go up over the next life of this legislation. Thank you very much. Have a good day.
And Assemblyman Ed Robb.
Thank you, Presiding Officer. I'm glad to join with our representatives of our law enforcement today, my colleagues in the county legislature. I recently introduced what I believe is the first amendment to this bail reform. Basically what it deals with is what Presiding Officer Nicolau talked about earlier, which is drug offenses. There are 4A felony drug offenses dealing with possession and sale of narcotics, and we're talking about things like the fentanyl that's being mixed in with heroin that's causing overdoses right here in our county, and those are specifically excluded by the bail reform law from the list of crimes that are eligible for what we have traditionally looked at as bail. Those individuals, and these are charges that prosecutors themselves have said they use to charge and build cases against major drug kingpins, the judge is going to have no say whatsoever other than to just release that individual when they come before them, without consideration to their dangerousness, without consideration to whether they're a flight risk. None of that can be considered. They have to just let them go. So I'm proud to stand behind the men and women of law enforcement in Nassau County and my colleagues. This is something that needs to be done, not next session. We have about 6 weeks left in Albany. We have to address it now. It goes into effect in January, and if anybody thinks we're going to go back and change it after the fact, after it goes into effect, they're sorely mistaken. We need to do it now before we create a public health and public safety concern in our communities. Thank you.
Thank you, Assemblyman Robb. And we have with us today Mary Ellen Gormley from Mothers Against Drunk Driving. Thank you, Mary Ellen.
Hello. I just wanted to speak to you today as a mother who had to experience her 3 children wondering if their father was going to survive a horrendous car accident from a drunk driver 15 months ago. My husband, Brian Gormley, was struck by a drunk driver, and if this new reform goes into play, this case would have been very, very different. And the person who committed this horrible crime would not have to post bail. This would be horrible for the victims. I am speaking to you as a Nassau County resident and a victim of this, and please, it's such an important aspect that we need to try to have it stopped in Albany. And as far as Mothers Against Driving Drunk, I am a representative of them too, and please, I just wanted to thank you. The sentencing was just last week, and I am confident that the case would have been very, very different if this new reform goes into place. Thank you.
Thank you very much, Mary Ellen, for those words. Does anyone have any questions they'd like to ask about the issue? Alrighty, so hearing none, thank you very much for attending, and thank you for all of you for coming with us and supporting us on this. As Assemblyman Rogers said, this has to be changed in the next 6 weeks. We can't wait to this. So we urge our state legislators to go back to amend this or just repeal it outright and start all over again. Thank you again.